Hello, we at Compliance Dashboard are right here with you still. So this video is a follow-up to the video on the Families First Coronavirus Response Act. This video will cover the CARES Act, or the Coronavirus Aid, Relief, and Economic Security Act. The amount of legislation coming out of Washington is amazing, and we are there with you, and we are reviewing it, and we are updating our website as necessary to provide you information that you need. So this video is going to summarize information that is on our website dedicated to the COVID-19 information and how it impacts benefit plans. We have blogs, we have resources by state, and we have information discussing its impact on health plans. I'm going to run through this information, and I have my computer in front of me because there's a lot of it, so I want to make sure that I cover this correctly. So on March 23rd, the third major piece of legislation was released, and that's the CARES Act. Again, the Coronavirus Aid, Relief, and Economic Security Act. So these are additional provisions, some that modify the FFCRA and some that are new. So let's run down what this is. First, we have expansion of coverage for the COVID-19 testing. So again, this expands the coverage from what was previously mandated in the Families First Coronavirus Response Act that was signed into law March 18th. Now the CARES Act, remember, is effective March 27th. So when we talk about group health plans, they must now cover, without cost sharing, the following diagnostic tests: FDA approved tests, tests for which the developer has requested or intends to request FDA emergency authorization, and those tests developed in and authorized by a state that's notified HHS about its intention to review the test. And there are some others as well. Secondly, reimbursement for COVID-19 testing. So now a group health plan or a health insurance issuer must reimburse the provider of diagnostic testing with one of two rates: the negotiated rate with the provider prior to the public health emergency, or absent that rate, the plan shall reimburse the provider in an amount equal to the cash price for such service listed on a public internet website. The CARES Act also mandates that each provider of a diagnostic test must post the cash price for the test on the provider's public website or incur a civil monetary penalty. Third, we have coverage for preventive services and vaccines for coronavirus. So the CARES Act will require group health plans and issuers to cover any qualifying coronavirus preventive services. So this is going to be any item, service, or immunization intended to prevent or mitigate coronavirus. The plans must comply within 15 days after a recommendation is made relating to the qualifying preventive service. Then we have an update for HIPAA. This is the confidentiality and disclosure of records relating to substance use disorder. So now the CARES Act modifies the Public Health Service Act regarding that confidentiality and disclosure of records relating to substance use disorders. So the purpose here is to underscore the importance of HIPAA's privacy rule for covered entities. Congress' purposes basically for those language modifications were to ensure a patient's rights to request restriction on the uses and disclosures of their records relating to substance use disorder, and compel a covered entity to make every reasonable effort to comply with the patient's request to restrict. So here's a summary of those changes in the CARES Act. So they wanted to make sure that it was consistently used that it's substance use disorder and not substance abuse. Number two, it expands the consent language. So in this case, once prior written consent of a patient has been obtained, those contents in that substance use disorder record may be used or disclosed by a covered entity, business associate, or special programs in accordance with HIPAA. Written consent, until it's revoked, need only be given once for future uses and disclosures for treatment, payment, and healthcare operations. High-tech restrictions on such uses still applies. And last, it adds anti-discrimination language clarifying that no entity or recipient of federal funds shall discriminate based upon inadvertent or intentional disclosure of substance use disorder records. These actions could include treatment for healthcare, terms of employment, sale or rental of housing, access to courts, or maintenance of social services. It's also important to understand there were several other provisions relating to the substance use disorder in this particular edit to the Public Health Service Act, and so that is also listed on our blog post about the CARES Act, so please make sure to check that out if you have questions. This is also a good time and a reminder that this video and the information we produce is not to be construed as legal advice. It is instead to be used for educational purposes. We always recommend you speak with your counsel and take a look at your business needs before you implement something. It's very important. Next, regarding the CARES Act and the type of change we have regarding benefit plans and how it could affect benefit plans, the Department of Labor has now the ability to postpone some deadlines. So there's language that includes public health emergency as a reason for the Department of Labor to postpone certain deadlines related to ERISA, for instance, filing the Form 5500. And of course, we will update you with additional guidance regarding those deadlines. Next, in the CARES Act, over-the-counter drugs and menstrual care products. So now the CARES Act deleted the requirement that individuals must obtain a prescription from a doctor to be reimbursed for over-the-counter medicines and drugs under HSAs, Health FSAs, Archer MSAs, and HRAs. Now, the Act also added menstrual care products as eligible medical expenses for purposes of these accounts. It doesn't appear that this alters the general rule for over-the-counter products, that the treatment must be for diagnosis, cure, mitigation, etc. However, it is important to still note that products intended for general health or well-being still do not qualify as medical care. And then telehealth services. The CARES Act encourages telehealth services. So there's various provisions within it to encourage the use of it and permit HHS, the Department of Health and Human Services, to permit these uses, including there's a high deductible health plan telehealth safe harbor provision. So in the case of plan years beginning on or before December 31, 2021, the CARES Act added a safe harbor provision to Section 233 of the Internal Revenue Code that basically says plans will not fail to be a high deductible plan for providing coverage of telehealth or other remote care services without a deductible. So in other words, the individual may have a plan that includes telehealth or other remote care without disqualifying them from their HDHP or high deductible health plan. Increasing Medicare telehealth flexibility. So during the emergency for COVID-19, the Secretary of HHS may waive all statutory Medicare coverage requirements for telehealth. And then Medicare assessments and certifications through telehealth. So before the CARES Act, certain assessments and certification requirements for Medicare beneficiaries must be done through an in-person or face-to-face. Of course, that's a challenge at this point in the time of social distancing and the importance of making sure we flatten that curve. So during the emergency period, these requirements for face-to-face encounters may be conducted through telehealth services. A couple more things to note. These are not necessarily in the CARES Act. These are a concurrent notifications that came out on April 3rd. Now, notification of enforcement discretion for business associate uses and disclosures of PHI and telehealth remote communication. So these are two pieces of information we felt important to share with you, especially as regards benefit plans, and HIPAA is always on everybody's mind. And now that the CARES Act did encourage telehealth services, regulations have to be modified when it comes to telehealth and HIPAA. We will have more information coming for you on HIPAA, so please check your blog and check the updated information on our pages. We know that that's very important to you. So regarding the two notifications, so that the Office of Civil Rights for the Health and Human Services sent out two notification of enforcement discretion. So this is enforcement discretion, which means Office of Civil Rights has discretion on how they enforce provisions of HIPAA. So specifically, the first one, the notification of enforcement discretion under HIPAA, permits uses and disclosures of protected health information by a business associate for public health and health oversight activities. effective immediately. So that was April 3rd, as a matter of that enforcement discretion. So they are not going to impose potential penalties for violations of certain provisions of the HIPAA privacy rule, specifically 45 CFR parts 160 and 164. And if you work in HIPAA, you kind of know, you begin to know those like the back of your hand. Now, they're not going to enforce those fines and violations against covered healthcare providers or their business associates for uses and disclosures of that protected health information for public health and health oversight activities during the COVID-19 nationwide public health emergency. Now, some specifics about that. Under HIPAA, as it is, business associates typically may use and disclose PHI only if it's expressly permitted by the business associate agreement with the covered entity. And covered entities are health plans, healthcare clearinghouses, and healthcare providers. Now, OCR will enforce discretion and not impose penalties on the business associate or the covered entity only if two things. The business associate makes a good faith use or disclosure of that covered entity's PHI for that public health activity or health oversight. And secondly, the business associate informs the covered entity within 10 calendar days after the use or disclosure occurs, or it begins for recurring uses and disclosures. Most important, all other provisions of the Privacy Rule are unchanged unless it's already been discussed by the Families First Act or the CARES Act. Security rule provisions for business associates and covered entities are still in effect with respect to this particular modification. Now, the enforcement discretion will remain in effect until the Secretary of Health and Human Services declares that the public health emergency no longer exists, or on the expiration date of the declared health emergency. Now, the second prong and the second most important thing I was talking to you about this particular add-on is that telehealth remote communication. So we have a notification of enforcement discretion regarding telehealth. So now, again, the Office of Civil Rights won't impose penalties for non-compliance with requirements under HIPAA rules against covered healthcare providers in connection with a good faith provision of telehealth during the COVID-19 nationwide public health emergency. So this notification, of course, is effective immediately. It was April 3rd. So regarding those telehealth services, a few things. A covered healthcare provider can use any non-public facing remote communication product available to communicate with patients. Again, it's a good faith provision. This discretion applies to telehealth provided for any reason, regardless of whether the telehealth service is related to the diagnosis and treatment of health conditions related to COVID-19. Facebook Live, Twitch, TikTok, and similar video communication applications are public-facing, and they should not be used in the provision of telehealth by covered health care providers. Now, of course, the Office of Civil Rights has recommended that these covered healthcare providers choosing to use telehealth services remember that they need to pick a service technology provider that is HIPAA compliant and will enter into a business associate agreement in connection with that provision of their video communication products. And of course, the Office of Civil Rights will not impose penalties against those covered health providers for the lack of a business associate agreement with video communication vendors or any other non-compliance that relates to a good faith provision of these telehealth services during this COVID emergency. So I just went over a lot of information. Please take a look at our blog posts and the reference pages on the website to go over everything that I just talked about. It's all there along with hyperlinks to the rules and what you need to know. So I want to say thank you for listening. We hope that this is of value to you, and we are still here and we are going to be here for you. Thank you.